in the state of Florida, we have a serious problem. The problem is not created by people breaking the law. It has been created in the state of Florida, which is contrary to the rights of every citizen of the state. The system that I'm talking about is related to the issue of child abuse. Child abuse, the cases are put together in the newspaper often. We see them on television. Many of those cases are horrendous situations that needed to be dealt with because it was obvious that criminal abuse had taken place. A child had been harmed. Chapter 827 of the Florida statutes. If a person abuses a child, neglects a child, abandons a child in this state, charges can be brought against them. That person would be taken into custody. The person who brings charges against them, we have the right in the state of Florida and in any state in the United States, a person has the right to be confronted by their accusers. They have the right to a trial by jury. They have the right to subpoena witnesses on their behalf. They have the right not to be compelled to give evidence against themselves. This is the criminal justice system because it's based upon the constitutional rights of every individual. But at the same time, we have a parallel system in the state of Florida created under Chapter 39, in which child abuse is not defined in the same manner as it is in Chapter 827. Child neglect is not defined in the same manner. Child abandonment is not defined in the same manner. In fact, the definition is so loose that the Department of Children and Families in the state of Florida, this system that I'm talking about, can make any situation be child abuse, abandonment, and neglect. A person can lose their children without having any charges really brought against them, any criminal charges. What's happened is that a system has built itself, and that system is based upon a good idea or a saint-seeming idea in the beginning that we're going to help children, we're going to help families. But in fact, it does just the opposite. Florida statute says that a child may only be taken into custody pursuant to the provisions of this part based upon sworn testimony either before or after a petition is filed or by a law enforcement officer or authorized agent of the department if the officer or authorized agent has probable cause to support a finding, 1, that the child has been abused, neglected, or abandoned, or is suffering from or is in imminent danger of illness or injury as a result of abuse, neglect, or abandonment. 2, that the parent or legal custodian of the child has materially violated a condition of placement imposed by the court, or that the child has no parent, legal custodian, or responsible adult relative immediately known and available to provide supervision and care. These are the only 3 provisions. It says only taken into custody. And yet that is not the case. The child will be taken away with only allegations being made with no testimony. The testimony that's given is seldom, if ever, the testimony of the person reporting the charges. They're made based on hearsay testimony of somebody who works for the department or somebody who works for the Safe Children Coalition or some other agency that receives their support from garnering cases relative to these accusations. These individuals, by hearsay testimony only, are creating these petitions and so forth. The individual, in fact, Florida statute says that an individual who reports these situations can only be found out who that individual is by the state, the individual to receive the benefit of these calls. The family who wants to know who it is who placed the charges against them so they can confront them in court, which is their right to do, can never find out who that individual is. A false case of child abuse will happen in a number of different situations, but a false report means a report of abuse, neglect, or abandonment of a child to the Central Abuse Hotline, which report is maliciously made for the purpose of A, harassing, embarrassing, or harming another person. B, personal financial gain for the reporting person. C, acquiring custody of a child. Or D, personal benefit for the reporting person in any other private dispute involving a child. We have ample law on the books to prosecute child abuse, abandonment, and neglect. But Chapter 39 puts a parallel statement where somebody who doesn't even, if I choose to allow my child to go to a party and that child gets drunk or gets molested or whatever as a result of it, I could be held in abuse as a parent. But if I refuse to let them go to a party or to a school dance or something else, I could be held as an abusive parent. If I don't let my child watch television when they want to, I could be an abusive parent. If I let my child watch too much television or watch things that cause them to get involved with wrong friends or whatever, I can be an abusive parent. If I choose my children's friends so that they don't run around with the wrong crowd, I'm an abusive parent. If I let my children run around with the wrong crowd, I'm an abusive parent. It's because the definition is so vague that anything can be made up by the department to bring accusations against a parent. If I let my child overeat and that child becomes obese, or I do the same thing to myself, I can become an abusive parent. If I choose to feed my child health food and be very cautious to do it, and they don't become overweight, and the standard that's used to measure failure to thrive by the system today is actually a standard based on obesity in the United States. If my child doesn't measure up to this standard because of whatever for a couple days or whatever, they lose weight as a result of something, that can happen. The situation is such that some children can be in the care of the state for a long period of time. They never reassess them. Failure to thrive as an accusation has been a constant accusation within many cases of the DCF reports. Diagnosed by a doctor who, by his own admission, will have to admit that you cannot diagnose failure to thrive only in seeing one visit by the child. It can only be observed over a progression of time, showing that the child fails to grow, because failure to thrive, while it has kind of a vague connotation to it, means failure to grow, that the child is not growing. That can only be observed over a long period of time to find out if the child is or is not growing, and what are the factors causing that. A parent disciplining a child, while the law says that cannot be the sole basis for it, the state can pull up all kinds of things to create situations to mask the actual charges that they're bringing against the parent. We have to realize that an individual who works for these agencies or who works for these departments, wanting to do well in their job, wanting to expand their job, wanting to be promoted in their job, can only do so like any other business if they have an abundance of clients. How does the state get an abundance of clients? They have to have reports. They have to have individuals coming in. We want to encourage those from our governor, our legislature, our local representatives, our court system, that there is a better way in the state of Florida. We have adequate law to deal with it. Chapter 39 needs to be eliminated. The Department of Children and Families needs to go to either becoming a service agency, providing only services to help families, but never getting involved in the prosecution of families. We leave that to the justice system. It should be dealt with as crimes in the state and only as crimes in the state. This idea of taking a child away to protect them from the parents when the parent has never been charged, never been had charges traced against them. We never need to take the child away. Take the offending parent away, or grandparent or whoever, caregiver, lock that person up, but protect all of their rights in the process, the same as anyone would want to have done to them. We appeal to those who watch this tape to see and hear the cases that are mentioned, to realize that the law provides adequate remedy, and that to correct the injustices that are being done day by day.